Okay, let's start talking about contracts, and we will begin with the topic of offer. Contracts are agreements. Remember that what we're looking for when analyzing problems is whether the parties agreed to something. This is fundamentally different from tort and criminal law because no obligation is created in contracts unless the parties agreed to it. Compare tort and criminal law, where we are held to societal standards whether we agree with those standards or not. Therefore, the first part of analyzing contracts is to determine whether there is an agreement. An agreement is defined in law as an offer that was accepted, with both the offer and acceptance supported by consideration. We will discuss each of these elements separately, but keep in mind that if any single element is missing, there's no contract. And note that the text sometimes talks about legally enforceable contracts. This is redundant. If something's a contract, it is by definition legally enforceable. If it's missing one or more necessary components, then it is not a contract and therefore it is not enforceable. Okay, first let's take offers. The first requirement in analyzing whether an agreement exists, i.e. an offer. In order to be an agreement, there must be an offer. For there to be an offer, three elements must be present. It must be promissory, it must be reasonably definite, and it must be communicated. So, what does promissory mean? We'll discuss each element separately. First, promissory is a requirement. This is sometimes called present intent to contract, which means that the offer's language, conduct, etc. is the equivalent of a promise. Note that the person who makes a promise is the offeror, and the person receiving the offer is the offeree. A quick way to check for it is to change whatever language was used to instead begin with "I promise" and see whether it is consistent with what the offeror apparently meant. For example, suppose that Kevin told Annie, "I will sell you my car for $10,000. Now, translate this into promissory language. I promise to sell you my car for $10,000. Is that consistent with Kevin's apparent intent? Yes. He used the language of commitment. He used a promise. If Annie said, "Yes, I'll buy it," then we now have a contract. Compare the following statement. Suppose that instead Kevin said, "I'm thinking of selling my car for $10,000. Would you be interested?" Is that the same as Kevin promising to sell his car to Annie? No. By the terms he uses, it's clearly not making a commitment. Kevin is simply trying to gauge Annie's interest in negotiating. For example, this is not an offer, therefore even if Annie said, "Yeah, I'll buy it," they still don't have a contract. Kevin never made an offer for Annie to accept. Now, what about the following? "I'm sick of my car. I would sell it to you for 2 cents. Is that an offer? A statement is promissory if a reasonable person interprets it as promissory. This is called the reasonable person standard. Would you think that someone was promising to sell their car for 2 cents? No, of course not. You can't just jump on language taken literally and commit someone to a contract. In context, this person is really saying, "I'm frustrated that my car is so much trouble." This is not an offer to sell the car for 2 cents. What about the following statement? I will sell you my car for $10,000, i.e. the same language Kevin said to Annie originally, with Annie responding with, "Yes, I'll buy it." What if after Annie says yes, Kevin says, "Oh no, I'm just kidding"? Using the same test, the reasonable person standard, would a reasonable person have understood that Kevin was just making a joke? No, not unless there were other factors not apparent in this hypothetical. The point is, we don't care about Kevin's actual intent with the "I was just joking" statement. We care about Kevin's apparent intent. Would a reasonable person believe he was making a promise? The cardinal rule of contract interpretation, applicable throughout our study of contracts, is that courts protect the reasonable expectations of the parties. If a reasonable person would have thought Kevin was serious, then we protect Annie's reasonable expectations and hold Kevin to the logical consequences of his statements. It's Kevin's job to make his language match his intentions, not Annie's job to figure out what he intended. How would you rule in the case of Sloan versus Jerry Falwell? Jerry Falwell, founder of the Moral Majority, denied that he had attacked a Sacramento area gay community church and offered the church's leader, Jerry Sloan, $5,000 if Sloan could produce proof that he had. Sloan produced a tape in which Falwell called the church, quote, a brute beast, part of a vile and satanic system that will one day be utterly annihilated, and there will be a celebration in heaven, end quote. After producing the tape, Falwell claimed to have been joking, not to be making an offer. Was he successful? No, held the court. Under the circumstances, it was reasonable for Sloan to have interpreted the language as promissory, even if Falwell were joking. Falwell was ordered to pay Sloan $5,000. Notice the facts supporting the court's conclusion that the amount of money was not outrageous, that the topic matter was something of interest to Falwell, and that Falwell made the statement to bolster his credibility. All of these factors taken together, the court effectively ruled, meant that a reasonable person would interpret it as an offer. In interpreting whether language is promissory, there are a couple of areas to look out for and pay particular attention. That is, advertisements and auctions. We'll talk about them both. Are advertisements offers? Is a merchant promising to sell you something that they've advertised? Think about it. If Macy's places a newspaper ad saying that they're selling Ralph Lauren polo shirts for, let's say, $39.99, have they promised to sell you a shirt? No, for a few reasons. First, when you read the newspaper, do you really think that Macy's is talking to you personally? Of course not. Macy's presumably wants to select customers with whom they do business. If you're in default on your Macy's charge card, for example, Macy's may not wish to extend more credit. Macy's, in other words, presumably wants to choose with whom they do business. Therefore, you can't assume that they're promising everyone who reads the newspaper that they will enter contracts with them. Also, a court would say that the ad was not promissory because it was directed at a group, thousands, maybe millions of people who read the ad. But the readers must have understood that there was a finite number of shirts. You can't really believe that Macy's is going to sell an unlimited number of shirts to everyone who reads the newspaper. Courts protect the reasonable expectations of the parties, and you can't reasonably expect every newspaper ad to be a commitment. There are some exceptions, of course. Consider the following language in a TV ad. Quote, free to the first 50 customers who buy a car on Saturday, a free microwave oven, end quote. Would you interpret this as an offer? A court would say yes. Unlike most advertisements, this one is self-limiting. In other words, 50 people. And the merchant has, by definition, selected the offerees by choosing to sell them cars. So the statement is, therefore, promissory and therefore an offer. Let's talk about auctions. Is an auctioneer's call an offer? Or if you're in an online auction, for example, eBay, is posting an item an offer? Let's suppose you are at a live auction. The auctioneer, after identifying something to be sold, let's say it's a horse, says, do I hear $12,000? Is this an offer? Is the auctioneer promising to sell the horse to everyone present? Well, of course not. There's only one horse. You can't reasonably interpret this language as a promise. There's only one such horse, and there may be hundreds of people present. They can't all think that the auctioneer is promising to sell each of them the same horse. In addition, the context itself isn't promissory. By saying, do I hear $12,000, the auctioneer is effectively saying, will someone bid $12,000 for this horse? The auctioneer isn't promising to sell you the horse for $12,000. He is trying to get you to offer to buy the horse for $12,000. Do you hear the difference? The auctioneer isn't promising anything anyway, since if someone is willing to pay $13,000, they will take that bid over your bid. How about if you raise a number card that the auctioneers gave you to use for bidding? If you make a bid at $12,000, have you made an offer? Are you promising to pay $12,000 for that horse? Yes. Is there a contract to sell the horse for $12,000? No, not yet. The auctioneer is free to see whether he can get $13,000, and if not, to slam the gavel down and say sold for $12,000, thereby accepting your offer. What about the following? Suppose at a horse auction, the auctioneer was calling for a bid starting at $15,000. A woman arrived at a busy, noisy, crowded auction tent, saw her husband across the room, and enthusiastically waved at him. Sold for $15,000, called out the auctioneer after seeing the woman wave her hand, and incidentally, this is a true story. Did the woman make an offer? Do we look at her actual intent, which was to greet her husband, or do we look at what the auctioneer thought her intent was, that the woman was making a bid for $15,000? The latter. If it's customary to make an offer at a live auction by raising your hand, then the woman just made an offer. We don't care about what the woman was actually thinking, rather how a reasonable person would actually interpret the woman's words or conduct. Here, conduct, not words, is the way an offer is made, and under the circumstances, the auctioneer reasonably thought the woman was actually making a promise to pay. The second element of an offer is that it must be reasonably definite. What this means is that there are enough details to determine what the offeror was meaning to do. If not, the court will determine that there never was an offer. This doesn't mean that you need all of the details. It's possible to discover in any offer some missing detail. Rather, you're looking for enough specificity so that you can figure out what the parties were agreeing to. It is routine for courts to supply missing terms if they can determine what the offeror intended. This sounds more difficult than it really is. Suppose Mary said to Debbie, "I'll sell you my car for $12,000. Is it reasonably definite? What details are missing? Let's assume that Mary owns only one car so that we know the subject matter of the offer. Do we know where the sale is to take place? In what form, for example, cash or check, Mary will accept payment? How soon will the sale take place? Well, Mary didn't specify any of this. Despite that, a court would probably conclude that Mary made an offer because we can presume what she intended. That is, a court would probably conclude that Mary, as a reasonable person, probably intended that the contract would take place where the car was located, that in the sale of a used car by private parties, cash or cash equivalent was intended, and that the sale would take place in, let's say, no more than a week. Mary therefore made an offer because it was reasonably definite. One way to check whether something is reasonably definite is to pretend you're the judge. Do you have enough details to tell what the parties meant? You're a judge, remember, not trying to enforce the parties' agreements, not try to monitor them to perfection, or to allow technicalities to permit others to evade agreements. At the same time, if the parties didn't give enough information to tell what they were agreeing to, then there's no offer. It's not reasonably definite. Be careful here. We're supplying missing interpretations based on what Mary, as a presumably reasonable person, would have intended, but that doesn't mean that offers must be reasonable. If I email you and say, "I'll sell you my house for $500,000, sight unseen," and you have 2 seconds to decide, have I made an offer? Yes. Is it reasonable? No. But the offeror is the master of the offer and can construct the offer as they wish, and you're free to reject it, as presumably anybody would. The third element is communication. This means 2 things. First, that the offeree knew or should have known about the offer, and second, that the offeree reasonably assumed that the offeror intended to make an offer. Again, this sounds more complicated than it really is. Let's take the second point first. Suppose that you apply for a car loan at your credit union. You get a letter from your credit union, signed by the loan officer, approving your loan. You sign the acceptance and return it. The loan officer calls you, apologizes, and says that due to a clerical error, they never approved you for a loan. Did the credit union make an offer? The test, again, is whether you thought that they intended to make you an offer. Well, the letter sure looked official, and it's how such offers are customarily made. The credit union's actual intent, again, is irrelevant. Since you reasonably thought that an offer was communicated to you, then it was. The credit union is stuck. Suppose, on the other hand, that the credit union never sent you a letter. Instead, a friend of yours works at the credit union, called you and said, "I'm not supposed to tell you this since I'm just a teller trainee, but you got approved for the car loan." Did the bank make an offer? Of course not. You couldn't reasonably believe that an offer was intended in that form. In fact, your buddy told you that he wasn't authorized to extend an offer. You don't have the power to accept. There's no agreement. Let's return to the first definition of communication, that the offeree knew or should have known about the offer and its terms. This one's a bit more subtle, and it sometimes comes up in the context of whether particular terms are included in a contract. Suppose that you drive into a pay parking lot, take a time-stamped receipt, and leave your car there. You parked next to the attendance booth. When you return, your car has been broken into. Could you argue that the parking lot company breached the contract with you for the safe storage of your vehicle? Maybe. Did you have a contract? Certainly, you agreed to pay the parking lot company and they agreed to permit you to leave your car there. After you try to get them to pay for the damage to your car, the company is likely to direct you to the language printed on the reverse side of the time-stamped card, beginning with, "This does not create a bailment," and going on from there. The company will say that this provision was a part of their offer, i.e. that they're not responsible for the damage to your car while it's parked there. The question isn't whether there was a contract, there certainly was, but whether the small, oddly worded print on the back part of the ticket was part of the contract. Was the language communicated? Would a reasonable person have read and understood it? Maybe. Would a reasonable person have read it? Probably not, but would a reasonable person have understood it even if they'd read it? What is a bailment anyway? This is archaic language from common law. On the other hand, such limitations are routine, so the company would argue that a reasonable person knows that a limitation of liability is included in such parking lot agreements. Does it make more sense now why there is a big sign in front of the time-stamp machine as you enter? Why there are signs posted throughout the parking lot saying "We're not responsible"? The company is trying to establish that a limitation of liability was communicated. Now, think back on all the contracts you've entered where the other party wanted you to initial particular paragraphs or where certain language was printed bold or in another color ink, for example, red ink in an otherwise black printed document. Why did they do that? Were they really worried about whether you saw it? They probably don't especially care, but what they need to do is to demonstrate that a reasonable person would have read it and understood the provision. Whether you actually did so is not what they have to demonstrate in the event of a contract dispute. They just need to show that they brought it to your attention and that a reasonable person would have read it. What this means is that you need to be sure to use language that is comprehensible to those who are entering an agreement with you and to draw their attention in ways that you can demonstrate later. In other words, in writing, to important terms. Let's talk about termination of offers. Suppose on January 14th, you offered to sell your car to Kim for $6,000. On April 12th, she answered, "Great, I'll buy it." Do you have a contract? Well, you certainly made an offer, but was it still alive when Kim tried to accept it? 4 months went by. Did she really think you were waiting around for an answer? Well, while you certainly made an offer on January 14th, there was no offer still in existence on April 12th. It had died of old age, or, in legal terms, it terminated through lapse of time. Offers die in particular ways, including rejection, revocation, and lapse of time. Here are some examples. Rejection. Annie offers to sell her car to Stephanie for $12,500. Stephanie replies, "I'll give you $11,500. Annie replies, "No thanks." Stephanie then says, "Okay, I'll pay you $12,500. Do they have a contract?" Let's take it apart. Annie offers to sell her car to Stephanie for $12,500. That's an offer. Stephanie replies, I'll give you $11,500. Well, that's a counteroffer. Counteroffers operate as normally as rejections of the offer, thus killing the offer. Annie replies, no thanks. Rejection of the counteroffer again is killing the counteroffer. Stephanie then says, oh, okay, I'll pay you $12,500. This is a new offer. Stephanie thinks she's accepting the original offer, but the original offer is dead. Do they have a contract? No, not unless Annie accepts Stephanie's new offer. Now let's try one with revocation. And on all of these examples, I really recommend that you write them down. It's easier to go through and characterize each one when you see each communication listed. Here's an example. On January 12th, Annie offers to sell her car to Stephanie for $12,500. That same day, Stephanie replies, let me think about it. The next day, January 13th, Annie says, never mind, I sold it to Ben. Stephanie says, well, but I was going to buy it. Did Annie breach a contract? Again, let's take it apart. First, on January 12th, Annie offers to sell her car to Stephanie for $12,500. That's an offer. That same day, Stephanie replies, well, let me think about it. Legally, this is nothing. It's not an acceptance. It's not a rejection. The offer is still open. On January 13th, Annie says, well, never mind, I sold it to Ben. That's the equivalent of a revocation of her offer. When Stephanie says, well, but I was going to buy it, Stephanie is attempting to accept the offer, but the problem with Stephanie's attempted acceptance is that there's nothing to accept. The offer was revoked when Annie told Stephanie that she'd sold the car to Ben. Now, here's our third and final example of a termination of offers, lapse of time. As we discussed when we started this section of termination of offers aren't good indefinitely. They die from old age when they terminate due to lapse of time. This can be a term set forth in the contract. For example, I'll pay you $450,000 for your house. This offer is open until midnight, November 12th. Even if they don't have a deadline in the offer, however, courts will simply supply that missing term, in other words, the deadline, assuming the parties intended a reasonable deadline given the circumstances. No one would think an offer to sell a car would remain open for 4 months, so Kim is out of luck. That concludes our discussion of offers.